Good evening or good morning if you're on the other side of the pond. I am Bob Mata, and I am your host. This is Defense Diaries, and I am joined, as always, by my much better half, my beautiful and brilliant co-host, Allie. What's up, girl? Muted.
Hey, babe. Hey, all. Lashana Tova. Is anyone out
love
there who is celebrating?
Yeah, Allie just whipped us up a fabulous meal.
Yeah, we celebrated late.
Yeah, her famous matzo ball soup. Yeah, that's why we're late tonight. We were celebrating the holiday, and it was delicious. Thank you for all of that. So
We're late because, when you got a fireman for a son, you got to work around the schedule.
Indeed you do. So this thing's been out for a hot minute, and this thing that I'm talking about is the Bederow bombshell, the mega motion, along with the accompanying memorandum of law, which, frankly, that's where you got to start, right? Well, no,
Well, the memorandum is the mega motion, right?
He calls the whole thing the mega motion. So the affidavit's 88 pages. The memorandum's only like 35 though. So like the affidavit, there's tons and tons of stuff in there. So Allie and
I was just going to say the affidavit is used to set forth all of the facts in support of your motion. So that an affidavit is going to be fact heavy. It's just going to boom, 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 provide factual basis to support the motion.
Yeah, and I think you're probably, if you're familiar with the channel, which if you're new to the channel, why don't you go ahead and subscribe? Give us a nice subscribe. If not, at least give us a like. But we'd prefer if you liked and subscribed and shared. Help get us out to the world. But what we typically do on our channel is we often read through the entire document, seeing that we're talking about 120 plus pages, and it's 9 o'clock at night for us, 10 o'clock for our East Coast brethren. We're not going to do that. What we're going to do is we're going to kind of summarize it, give you all the main points that we think are germane and are worth talking about. And we'll do the same thing with the affidavit, right? You agree, babe?
Absolutely. I mean, to start out, what is the motion, first of all, babe?
So the motion, and it's really a motion to dismiss, okay? And the way that they've done it in terms of the way that Bederow has done it is it sounds like they do fact pleading out there, or I'm sorry, notice pleading, meaning that they're not going to, in the body of the actual motion that you file, says, here I'm filing a motion to dismiss, and then you put all your facts and argument in there. Instead, they do it via a memorandum of law. And then in this particular case, he supported it with his affidavit. So what we're going to be going through tonight are the memo of law and then the affidavit itself, but it is for a motion to dismiss.
In which case is it in?
It is in Aidan's, what I consider to be the more important of the two cases, which is the multiple count witness intimidation case, wherein, in my estimation, they are trying to silence a reporter, silence a critic. And
give him how many years? Was it like 106? I forget.
it's a lot of time.
It's a lot of time.
It's a lot of time. If he were convicted on all of them, and if he were to get the maximum, which he wouldn't, but still, it's a massive amount of time. It is an incredible amount of time to have hanging over your head every moment of your life until this thing's resolved, which, you know, Aidan can put on the brave face, and he typically does, but like this thing is just something that would be constantly running through your mind. Like you'd never be able to not think about it. You've got great things going on. Oh, well, you know, I still got this case, because you never know what's going to happen in a court of law. So it's always a terrifying proposition. And, you know, I mean, fortunately, he's got some pretty damn good lawyers working for him. So I think what we do you want me to pull up the document, even though we're not going to read it?
Why would you do that?
I don't know. I'll take that as a
well,
no.
Let's start with the motion raises two primary arguments for dismissal. First, grand jury misconduct, and second, Brady discovery violations. So let's start with the grand jury issues. They're pretty dramatic.
They are. And the legal standard here is found in Commonwealth v. Odell and Commonwealth v. Mayfield. And the defense needs to show the prosecution impaired the integrity of the grand jury proceeding itself through false or misleading evidence that was probably significant and presented with the intention of seeking an indictment.
Right. And the defense is alleging some pretty serious misconduct by Special Prosecutor Kenneth Mello and Detective Lieutenant Brian Tully. They claim Mello knowingly presented false testimony 28 separate times about Kearney's video episodes, so YouTube, being admissions of witness intimidation.
That's so fucked up.
It's crazy.
It's crazy. The key allegation is that
Tully
edited Kearney's actual video episodes at the direction of a woman named Katherine Peter. And if you followed this case and you're on Twitter, you'll know who Katherine Peter is. I think her Twitter moniker is Mafia Mass or Masshole Mafia. So and she is who the defense characterizes as Kearney's enemy.
Right, in the motion
With a history of fabricating evidence against him. So then Tully created an intent folder. So he creates an actual folder and he entitles it intent. And then he tells the grand jury that these edited clips came from Kearney's own folder named intent.
Wow. I mean, that is fucking devastating if true. And I'm assuming it is. I mean, the defense, so they cite to a case, it's Commonwealth v. Bleakney. It's an August 2025 case where the court dismissed rape indictments because the prosecutor misled the grand jury about the full context of defendant's statements, which that we have here. You know, we definitely have that here. You've got like edited clips taken out of context, But here the defense argues that Mello went even further. He didn't just hide the context, but he fabricated evidence. He presented fabricated evidence.
I mean, when you're thinking about it in terms of the government pulling this kind of shit, it should terrify you. And if it doesn't, there's something wrong with you. So the defense is also claiming that Mello spent an entire day presenting irrelevant bad acts evidence about alleged wiretapping that had nothing to do with the witness intimidation charges. And under Commonwealth v. Freeman, an introduction of uncharged bad acts can impair a grand jury's integrity, especially when done gratuitously without any kind of cautionary instructions.
So, and you know, like what we're going through here, again, these are all the arguments that Bederow makes that he presented in his motion. So let's assess the strength of the arguments. The grand jury misconduct claim has some real potential. If the defense can prove that Tully actually edited the videos and falsely claimed that they were Kearney's originals, that's huge. This whole intent folder, was Tully's creation, not Kearney's. If I think even if he was misleading about it, but if he came right out and told them that, I mean, that's huge. And then Mello knew all of this and like proceeded anyway. This could meet the Mayfield standard based on the sites they have in the motion. It could meet the standard for dismissal.
Yeah, and ironically, Mello's no longer on the case, and as of today, neither is Special Prosecutor Cosgrove. So this thing is floating out there like a rudderless ship, like this entire case. Like Cosgrove today had to withdraw because I think that.
Well, not. Oh yeah.
Yeah, I know.
I was thinking it was still the weekend. I'm like, not today.
Yeah,
Maybe it's Saturday.
yeah, honey, it's only Wednesday. So look, the challenge will be proving that Mello had knowledge and intent, right? I mean, that's always going to be the issue. Prosecutorial misconduct requires showing that the prosecutor acted knowingly or with a reckless disregard for the truth. And the defense,
I think they're fucking reckless. This is reckless disregard for the truth. The question is whether, a court will agree. But I mean, I think it's all laid out there.
Yeah, I mean, look, when we get to the affidavit, I mean, he's not coming without receipts. You know what I mean? He's definitely
88 pages of it.
Yeah, a fuck ton of receipts. So the defense has some evidence, aka receipts. They reference emails between Mello, Tully, and Peter that weren't disclosed until July of 2025.
Speaking of which, looking at the Brady discovery violations. This is where the defense might have an even stronger argument.
Yeah, well, the legal standards here are obviously going to be Brady v. Maryland for constitutional violations and Massachusetts Rule 14 for automatic discovery. There's a case in Mass called Kyles v. Whitley.
No, that's United States Supreme Court.
Oh, so under Kyles v. Whitley, prosecutors have a duty to learn of favorable evidence known to the prosecution team, including the Popo.
Yeah. Yeah, I mean, the prosecution's charge, because that used to be what they did all the time. I mean, we didn't know. I mean, the cops, sure, they were doing all this bullshit, but we're clean as a whistle. So Kyles v. Whitley says, go fuck yourself. We're considering the cops the same as prosecutors. Yeah. So the defense made multiple specific requests starting in September 2024 for evidence about Katherine Peter's role in the investigation. The motion alleges she worked directly with Mello and Tully, providing guidance on what evidence to present to the grand jury. I mean, what?
I mean, you know what I always do in a criminal case, that's attack the timeline. And the timeline here is damaging, not to Aidan, but is damaging to the prosecution because the defense made specific demands in September, in October, and December of 2024, but didn't receive key emails between Mello and Peter until July of 2025, almost a full year later. Even worse, some evidence was apparently deleted by Peter during this delay.
And then they cite Commonwealth v. Bridgman, which says that dismissal is appropriate where, one, the defendant suffers irremediable harm from the non-disclosure, or, and I think this is, where we're going to end up here, or should, prosecutorial misconduct is so egregious, deliberate, and intentional that it creates a presumption of prejudice. Because the problem is, I mean, I don't know, is there a trial date? Like if they have the stuff now, I don't know that it's, like the damage is irreparable.
I don't think there can be a trial date. And if there is, like right now,
there's not even a prosecutor.
Right. I mean, this thing's just floating out there in the ether.
Right. They're going to have to find a prosecutor willing to say with their prosecutorial integrity that this case warrants being prosecuted.
Which is going to be very difficult to do. I mean, if you're a prosecutor that has any integrity at all, are you gonna want this steaming pile of shit?
Brennan might do it. Brennan might do it.
Hank,
yeah, bring Hanky back.
Yeah, bring Hanky back. You know, I mean,
Fuck, we can't find anyone to do it. We got to call Brennan.
if they pay him enough money, he'll do it.
Mm-hmm.
You know.
No doubt.
So
And
yeah,
that's just our opinion, Mr. Brennan. This is an opinion piece.
but that's a real thing though. Like this concept that they're not going to be able to find a special, because it has to be another special prosecutor. Be very clear about that.
Right. Can't be someone in the Canton.
They're out.
Attorney's office. Right.
Yeah, the Norfolk County, they're done. There is nobody from that office that can try this case. So it's got to be a special prosecutor. And I mean, as crazy as the fucking Brennan thing sounds, I mean, money talks, bullshit walks with that guy, you know. But like, you've got to
in our opinion,
in our opinion, in our opinion, in our humble opinion,
right.
Yeah, I don't know, but that's a real interesting aspect of it. Like if I'm Aidan, I'm feeling pretty good about the fact that because look, if you have a reputation as a prosecutor and they're inviting you in on this case, you're going to say, all right, well, let me take a peek at what you got here. You know, the first thing that you're going to read is this. I mean, I'm going to read the most recent filings to see kind of what the procedural posture of the case is. And I'm going to read this. I'm going to be like, I'm going to go to all these fucking guys and be like, yo, like,
what part of this is true?
Right? Yeah. Like, how much of this do I need to fucking worry about, bro?
And
because
you have heard of free speech, right?
Yeah. Yeah. That's a thing. That's a thing. So the irremediable harm argument, I think, has merit here. So if Kate Peter deleted discoverable evidence,
that's true. If she deleted stuff, for sure.
Yeah,
Sorry.
during the Commonwealth's delay in disclosure, that evidence theoretically was gone forever.
How do you prove what she deleted, though?
Well, that's the thing. I mean, in this case, with all the shit that was going on with all the creators and, people on social media, in terms of like everybody's screen grabbing everything that everybody sends them,
and
everybody's recording conversations. It's just,
I might have to revisit the motion for this, but since when does deleted mean deleted anyway?
I mean, you're talking about like now all of a sudden we can't extract it.
Right.
Like we always get. I mean,
right.
That's the whole point of like, obviously Celebrite and Gray Key and all those fucking extraction tools that they have is to get things that were thought to have been deleted permanently and bring them back from the dead. Oh, here you are. That shit you thought you deleted, it never really went away. It was still.
But remember, the defense, unlike the police, can't be like, all right, give me a warrant for all of her computers and all of her devices. And, the prosecution has to do it.
Yeah. So the defense is going to argue that they can no longer present their theory that Peter orchestrated the case against Kearney. I mean, which is true, and to a certain extent. If she deleted damning text messages wherein it would have showed a pattern and would have shown planning and would have shown coordinated efforts between Peter and people that are employed by the Commonwealth, that's a fucking big deal.
We got to be realistic, and we know what the court's going to be like. Well, you can't even tell me what you think she deleted. Like how you don't know what she deleted to know how prejudicial it would have been. Like, are you even putting forth a theory of what was deleted? But also being realistic about likely outcomes, whether Bob and I think the motion is strong, which we do. Massachusetts courts are generally reluctant to dismiss indictments, as most states are, preferring lesser sanctions. But this case does have some compelling factors.
Look, if all this shit is true, there is no way this case should be going to trial. This case should be kicked out on its ass, and people should be charged on the other side of it. If they went through this kind of shit in order to silence this guy, that they didn't like the shit that he was saying because they were so hell bent on getting a conviction against Karen Reed,
or because they wanted
They
Right.
had to shut down her mouthpiece.
Right. Or because they really wanted, uh, like people like Jen McCabe and all those people to actually testify, basically threatening, like, if you want me to testify, you better do something about this.
Right. Well, I mean, to me, that all circles back to
Right.
being hell bent on getting Karen Reed convicted.
Right.
Whatever
At whatever
cost.
cost.
Because I mean, we all heard the things that like the allegations that the McCabe's and were saying like you got to get this guy arrested. I don't know if any of that's true or not. I mean, I certainly heard the rumors, that they were kind of directing the Commonwealth to say, you got to get this guy off this fucking case, come
Well,
hell or high water. And if it's in jail, all the better as far as we're concerned. I mean,
we'll see some of it when we switch over to the affidavit.
yeah. So, as far as the grand jury misconduct claim goes, that there's obviously always going to be several hurdles that come along with that. One, the defense needs to prove their allegations through testimony and exhibits, which theoretically I think they'll be able to do. Two, even if proven, courts sometimes find alternative remedies sufficient, which goes to what you were talking about. Look, dismissal is the most extreme remedy. It just is, and it's not just in the Commonwealth, it's in every state. Judges are not, champing at the bit to dismiss cases. They'd rather have it get litigated, and it's pretty rare to see a full dismissal, everything gone. But that's not to say that it can't happen, obviously.
Right.
And then third, the Commonwealth will likely argue any errors were inadvertent or harmless. Oopsies. Those are
Right.
just boo-boos.
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 However, the defense has some advantages. As they cited in the motion, the recent, again, I think it's Bleakney decision shows that the Massachusetts courts will dismiss for grand jury misconduct. That is a recent case. That's a huge deal. That is very much in their favor. The Commonwealth's own emails seem to support the defense's narrative about Peter's involvement.
Yeah. And frankly, the Brady discovery claim might actually be stronger. The documented timeline of the specific requests and the delayed disclosure is really, really hard to dispute. I mean, it's kind of like you're going to have court orders saying, look, this is when you got to turn shit over. And if they don't have any kind of receipt that they turn shit over, there you go. It's right there for you. So the court has already ordered discovery completion by May of 2022, which the Commonwealth apparently violated.
Right. And I think that the defense could make a motion to compel the state to seize Peter's devices to do those extractions. If they've got the evidence that she deleted stuff, then there should be another extraction they can do to retrieve it somehow, some way. But the defense also,
I thought that there was, and let us know in chat. I thought that there was a move by Bradel and Bederow to get Peter's devices. Let us know in chat on whether or not that's true. For some reason, I remember that being a thing a few months back when we kind of first heard about Sofagate and all the other shit that was going on. You remember Sofagate, right?
I remember Sofagate.
Okay, so Sofagate was Kate Peter. All right.
I thought it was right with McKay buying her
right
a
the
sofa.
couch. Right.
Yeah. Oh,
So
thanks for all your hard work. Here's a couch.
Here's a new sofa. Enjoy.
But the defense also has some benefits from the Rule 14 March 2025 amendments, which they go through in the motion, and it expanded disclosure requirements to explicitly define favorable evidence to include information that calls into question the prosecution's version of the facts and shows witness bias.
And I think that there's probably like one strategic issue that the defense filed this as their second motion to dismiss. That could cut both ways. It shows ongoing problems, but the court might be skeptical of repeated dismissal requests because he did file the first one and this is the second one.
But they withheld yeah.
Exactly.
Right.
Exactly. I mean, he got more shit has come to light.
Right.
More shit has come to light. And
Right.
I
But the
think that
court
that
can't,
warrant.
if the court wants to blame anyone for repeated requests, then it has to be the Commonwealth for not turning over shit timely.
Right, because Bradel and Bederow have a right to try to adjudicate this as quickly as possible so that it's not hanging over Aidan's head for the rest of his life. You know
Right.
what I mean? Like they
Right.
shouldn't have to fucking if they're gonna slow play discovery or discovery is going to be destroyed and not turned over, or whatever the case may be, that's fucking on them. That's on them, especially in light of the fact I think that when we have a situation wherein there were discovery deadlines in which it was supposed to be tendered and then the state blows it repeatedly, that's on them. That's not going to be on the defense. And I'd be hard pressed to think the court is going to bust balls about the fact that there was a second motion to dismiss filed
Right.
based on new information.
Right. And I don't know if the Commonwealth has responded yet, but they're likely going to argue that any grand juror errors were harmless. It's something that can be cured either at trial or, I don't know, going to a grand jury again. That discovery delays don't warrant dismissal, just sanctions. And that the defense is making inflammatory allegations without sufficient proof. I'm sure that's what they'll argue. Whether there is sufficient proof, we'll have to see at a hearing.
Yeah, I mean that's the thing. To me, and we'll kind of summarize it when we get to the bottom of this particular motion. But in terms of the most likely scenario, in terms of what should happen, there absolutely needs to be an evidentiary hearing.
Oh, for
Like
sure.
I don't see any way around that.
No.
So, but the other problem for the Commonwealth is that they face credibility issues. Special Prosecutor Mello apparently has a history of disciplinary problems, and the defense alleges that he violated court orders and made false representations about the discovery itself.
So, look, I actually do think there is a possibility for dismissal here. I don't think it's outside of the realm of possibilities. These are serious allegations, but dismissal is still the most extreme remedy. But I think there's a chance.
Oh yeah, I think there's like this is not a frivolous motion. Like
No.
in any way, shape, or form. This thing has teeth, and it's got just it stinks in terms of just the fact that the Commonwealth was in cahoots with people that were on social media that had axes to grind against somebody who's now been charged criminally, who is looking at a fuck ton of time if he's convicted. And it was really just to shut down a narrative that he was putting out there. Yeah, I mean, if you get down to the brass tacks of it, they wanted to shut him the fuck up. Like that, it's that simple. So I mean, to me, when you get down to whether or not they're actually going to be able to find another prosecutor, which I think is going to be very challenging. I just do. I don't see a bunch of prosecutors lining up to fucking try this turd. I mean, you're going to have to look at it. Like prosecutors are not in the business of losing. I know that prosecutors like to pretend that they care about justice and all this and that. They care about winning. They care
I
about
mean,
they care
I'd
about
like I'd like to agree and think the same, but in the same breath, I'm like, some people will do anything for the spotlight for a while.
I guess. I mean, to me, if you're a prosecutor and you consider the spotlight to be a big L,
Right.
then maybe like you're in the wrong profession, bro. Because like
Right.
that's not how you get fucking elected. And I mean, it's just to me, it's not the move. But like you said, takes all kinds. Takes all kinds.
Yeah.
So I don't know. I think that the way that this thing will go down, I think without question, without I would be stunned if there wasn't an evidentiary hearing. I mean, there has to be an evidentiary. The judge should want answers. If I'm a
Right.
judge sitting on this fucking case and these allegations come across my bench, and I'm looking at prosecutors that practice in front of me, and I'm sitting there scratching my head. I'm like, are these fucking people like actually doing this shit? I want to know, like for my own edification, first and foremost, and then so that I can rule on this thing in a way that is going to either lay the hammer to them if this stuff is true or not. I need to hear the evidence. I want to hear the witnesses. I want to hear these people explain themselves in a court. And that's one of the nice things about being up on that bench. You got a whole lot of power. If you're a curious person,
right,
and you want to know what's going on, like in that robe, you've got all the power in the world to say, you know what?
ton of judicial discretion.
It's judicial discretion, and we're going to have an evidentiary hearing, and I want to hear all of it.
I mean, an evidentiary hearing alone would be a pretty big victory for the defense because it allows them to develop the misconduct allegations publicly and really embarrass the prosecution worse. I mean, worse than they have been, just showing that this is like, it didn't just start and end with Karen Reed.
Yeah. Yeah, no, I agree. But like what we've talked about, one of the primary reasons that we've really wanted to cover this case is, to me, the First Amendment implications in it are just so important. So important, because if we start weaponizing criminal statutes in order to shut reporters down, whether you fucking hate what they're saying or you don't, it matters not. That's the entire point of the First Amendment and freedom of speech, is that, if we all agreed on everything, we wouldn't need a First Amendment.
Right.
You need a First Amendment when people are saying things that you staunchly disagree with, and have the understanding that they have the right to say it and they have the right to think it. So, in this particular situation, whatever Kearney was coming with in terms of his coverage of this case, it cannot be denied in any way, shape, or form that he's a reporter. You just we're not in the Edward R. Murrow times anymore, kids. I got fucking news for you. I learn more on Substack than I do in any newspaper. I'll tell you that right now. Times have changed. How we are disseminated the news in this country ain't what it used to be. This isn't the 50s and the 60s and the 70s or the 80s or the 90s. Everything has changed. With the advent of the internet, everything has changed in terms of the ability for regular folk who didn't necessarily say go to journalism school, who decide, you know what, I want to start reporting on some shit, and they do the digging and they dig up stories and then they write about that story. That's reporting.
Right.
It's that simple. So,
go back to what you were saying about the more like the likely outcomes if, absent dismissal.
Yeah. So if it doesn't go as far as absent dismissal and other than the evidentiary hearing, I think this one's tougher because I don't know exactly what they would suppress, but there always suppression of specific evidence can be used in terms of things that they presented to the grand jury that they framed in a certain way in order to get the indictment. I mean, obviously those types of things could be suppressed and they can't be used at trial, especially like if you're the defense, you almost want them trying to pull that shit at trial.
Right.
You know what I'm saying? Because what I'm putting on in evidence is, okay, so the Commonwealth just showed you this bullshit and this is what they titled it. Okay, now I'm going to actually show you the actual YouTube video and this is what it was actually titled. But for the purposes of getting the indictment, it's a different thing. You know what I mean? In terms of the witness intimidation side of it, it's, because really they're trying to hammer this round peg into this square hole, or square peg into the round hole of this statute working here when it's not what it was designed for by the legislature. It's not why they created this statute. Witness intimidation statutes really were born out of old mob cases. It's kind of the same way that RICO was born out of trying to get the mob and the mafia under control and trying to create some kind of avenue for the federal government to be able to arrest these guys because they weren't able to do it on individual counts. And so, I mean, the witness intimidation statutes are developed to protect witnesses that are testifying in a court of law from people that are seeking to do them harm in order to stop that person from testifying or change their testimony.
Yeah, like leaving a horse's head on their bed.
Yeah, like going out and, we're talking about The Godfather in case you've never seen it. So, but yeah, I mean, Aidan Kearney going out and basically reporting from a perspective that was not necessarily objective. He was very subjective about what he thought, right? Which I think is where lines are blurred for some people in terms of what old-timey reporting used to be. Old-timey reporting used to be this concept of objectivity, right? Like that the reporter was just the one out there, a fly on the wall, digging up the evidence, digging up the story, finding the sources, and then reporting it, not having a position on it one way or another. Times have changed. Times have changed. And when you think about some real investigative reporting, especially where they're digging in, and you talk about like Spotlight and some of the other huge cases that were uncovered by some of these incredible investigative reporters that have been like just bombshells.
Right.
Like that kind of stuff comes from reporters digging deep and taking a position on something and putting themselves sometimes at risk, and there is no dispute here that maybe Aidan didn't put himself in physical harm's way, but he certainly put himself in harm's way in terms of, look, they might come after me and fucking arrest me on this shit, which is exactly what they did,
Right.
So, I mean, so the suppression thing, can you think of anything like
No, I
specifically
mean,
in a type of case like this they would suppress?
I don't know. I'd have to think about it. But at the end of the day, like we were saying, the evidence you're hearing would be, would be a huge win to develop the misconduct and show the prosecutorial misconduct.
Yeah. I mean, for sure.
And if the courts, like they got to take action on that.
Yeah. And look, I mean, if you are the Commonwealth and you're coming out of the Karen Reed case, the ass whipping that they took there, and I mean, aren't you like a shrinking violet at this point?
Yeah,
Like,
because there was
how
so
much
much
do you want your
prosecutorial
ass to show?
right.
I mean, I don't know.
There was a lot of prosecutorial misconduct shown for the whole world to see, like even just with the inverted video and then with the back of the shirt and like people saw it right in front of their faces. So, that might be a reason for the courts to take this, to do something drastic in light of this.
100%. And I mean, the embarrassment side of it from the prosecution side is fucking real. Well,
Right.
if the people lose faith, and we've heard it enough during the two Karen Reed trials, that the people of the Commonwealth of Massachusetts have zero faith in either law enforcement or the judicial branch.
Yeah.
You
I mean,
know, I
Bederow's
mean,
motion emphasizes this is like created a quote crisis of confidence in Norfolk County law enforcement. And
yeah,
the court might really see this as a need for deterrence here, see a need for deterrence and take a drastic action.
yeah, and I mean, to me, there's broader implications from the case if the courts don't take a strong action against prosecutorial misconduct in general. Especially prosecutorial misconduct and discovery violations. Not turning shit over, Brady, is fucking disgusting. I
Right.
like like the state has every advantage to begin with, and if they're going to lie, cheat, and steal about the evidence that they have, even if it hurts their case, then they are awful people that should not be doing that job.
Right.
Because, like, going back to what I said earlier, this thing isn't about fucking wins and losses. That's not what our justice system is supposed to be about. And for too many prosecutors in this country, that's exactly what it is. And like I've talked about this a lot too, there is that just conflict. These are elected officials, and I'm talking about the prosecutors. They run on I'm a tough on crime person. Like, look at my conviction rate. That's what they run on. So they create this conflict for themselves in terms of saying, you know what? I'm going to look at everything on its face, and I'm going to deep dive into it, and I'm going to decide whether or not this case is worth bringing, whether it pisses my cops off or not. Like, I have to look at it, and if I think it's a shit case, or if I think that they have the wrong person, or if I don't think that it went down with the same theory that the cops believe, then I don't bring the case. And it's the opposite of shame in that usually, like, I would champion any prosecutor that took that approach.
I mean, we saw the prosecutor in the Russ,
Yeah.
trial championed like that. And here you've got the defense has evidence that Peter previously fabricated evidence against Kearney in 2020, in 2023. I mean, that significantly undermines her credibility and should have undermined her credibility in if they were taking her as some sort of informant.
Yeah.
And do you think the wiretapping evidence is problematic for the prosecution?
I mean, yeah. Don't you? I mean, the wiretapping evidence, if you spend an entire day on uncharged bad acts, reading the criminal statute, including the penalties, then not seeking indictment, that just looks like prejudicial character assassination, frankly,
No, for sure. Well, I guess overall, like we said, it's a strong motion. It raises legitimate concerns about prosecutorial misconduct. Even if it doesn't result in dismissal, it puts significant pressure on the Commonwealth and, could influence, like you said, whether somebody even picks up this case to move forward, another prosecutor, or possible like slap on the wrist plea negotiations, which would probably be the easiest way to resolve this damn thing.
100%. But I mean, if you're Aidan and they offer you some kind of slap on the wrist bullshit, I mean, are you pleading out, or are you going to like lie on the sword? Or are you going to take the thing to the
No,
mat?
I think you're going to take a slap on the wrist.
You're going to take a slap on the
you need
wrist.
this thing to go away. Like,
You need to go 100%.
That's what I think. But you know what I mean? So, but like the motion ties together the grand jury misconduct and the discovery violations as part of a pattern. And that's a compelling narrative. When you look at it all together, it demonstrates the importance of, investigating prosecution witnesses and let's get into the affidavit. Let's get into those receipts.
All right, you ready to do that?
Yeah.
All right. Okay, so for this, I made this slideshow. Do you kind of so basically the way we want to do the affidavit, which is going to be all kind of the receipts that we heard about in the memo. Do you want me to throw up these slides? They're just
Sure.
kind of they're just little quotes of like areas that in the motion that
Like stick
we
up
quoted.
one slide until you're ready to do the next, and we'll talk. We'll talk over them.
Yeah, exactly. So, look, this affidavit is, if you know anything about the Delphi case, then you know about the Franks memo. And the Franks memo was that epic 130 plus page memo that was drafted by Richard Allen's defense team. So this thing rivals it. It is a massive legal document. Bederow spent a fuck ton of time developing this motion and developing his allegations and this evidence in order to put this thing together. It's like I was kind of wondering where Mark has been recently in terms of like not being on YouTube as much, because I've been trying to get him on for a few weeks.
He dropped a nuclear bomb on the Massachusetts judicial system.
Yeah.
And there's explosive details all throughout the motion and the affidavit.
I mean, for sure. It's like it's insane. It's truly, truly insane.
And it paints a picture of how the Massachusetts State Police and Norfolk County District Attorney's Office orchestrated an elaborate scheme to silence an independent journalism. Aidan Kearney, aka Turtleboy.
The turtle. All right, so let me pull this thing up. So these little slides, look at that. Isn't that sweet? Look at how I made that thing. Talking about some amazing shit. All right, so for those that don't know, if you have no idea who Aidan Kearney is, also known as Turtleboy, he is a credentialed independent journalist with a large platform on social media and YouTube. He writes articles and regularly hosts live YouTube shows, which are generally 2 to 3 hours in length, and address numerous topics of public concern. And he really spends a lot of time trying to expose corruption. Like, I mean, it's just something that he does. So, as far
these are all direct quotes from the affidavit.
yeah, these are all directly quoted. So what I've done is I've plucked little things from the affidavit and I've created these fancy slideshows for you, like these slides. Do you guys like them? Pretty good.
We love them.
It took me thousands of hours to do this. So, but
According to the affidavit, Kearney writes articles, regularly hosts live YouTube shows, which generally are 2 to 3 hours in length and address numerous topics of public concern. His investigative work has exposed numerous examples of fraud, corruption, and wrongdoing.
Yes, that is true. Okay, so I'm trying to keep up with my little slides here.
Yeah, but your slides aren't going to mirror everything we're.
Yeah, they mirror, big mirroring. So, but here's where this thing gets interesting. So, when Kearney starts investigating Karen Reed in and around April of 2023, Kearney quickly realizes that the case against Miss Reed was far more nuanced than had been publicly reported up until that point.
The affidavit makes the claim that, quote, Mr. Kearney's coverage of the Reed case, which to date includes 528 Canton cover-up articles and hundreds of video episodes, virtually overnight transformed a mundane Massachusetts criminal case into perhaps the most high-profile and scandalous murder case prosecuted in the United States in decades, end quote.
I mean, you can't argue with that assessment.
No.
You just can't. If Aidan doesn't start digging in on this case and doing what he does, I got news for you. All of you in chat right now, all of you that have been watching the Karen Reed, none of us would have heard about this case. This would have been one of the hundreds of thousands of cases that go on every day in every state in the union that we would have heard nothing about. And, you know, his reporting on it is what made this thing what it is now. I mean, there is absolutely, I've said that a million times. There's no denying that. So 528 articles, hundreds of videos. This was not casual coverage. This was comprehensive investigative journalism.
And the results, quote, but for Mr. Kearney's reporting, disgraced former trooper Proctor would still be investigating serious cases for the MSP. Other members of the MSP, including Detective Lieutenant Brian Tully and the lead investigator against Mr. Kearney and Sergeant Buchanan,
also known as Bukkake,
wouldn't have been publicly disciplined for their misconduct. And the Norfolk DA's state police detective unit wouldn't have been dismantled due to their misconduct in the Reed case.
True, and true. So what we have ultimately is a journalist whose work directly led to Michael Proctor being fired, other MSP members being disciplined, and an entire detective unit being dismantled. And now the same journalist is facing criminal charges. Coincidence? Let's see what the evidence shows.
All right, so they get into Katherine Peter, basically painting her as the vengeful ex-employee, and she's central to the case. So, according to the affidavit, quote, Miss Peter worked for Mr. Kearney from September of 2018 until February 2020, when Mr. Kearney terminated her employment after he caught her stealing from him.
But wait, It gets worse. Since Mr. Kearney terminated her, Miss Peter's unhealthy fixation on needling Mr. Kearney seemingly has dominated her life. Now, again, these are all quotes directly from Mark Bederow's affidavit.
Is it Mark's affidavit or is it?
Yeah.
Oh, it's not Aidan's
Bederow.
affidavit.
Oh,
Okay.
yeah.
I mean, how does Mark know that Aidan
Well,
fired her in
Let me
September?
let me double check. Let me double check. We'll pull it up. Let's see. This one looks like the old one. Yeah, this is the. Yeah, I'm pretty sure it's Mark's. Like,
Yeah, I think we better double check. That doesn't sound right.
I know, because I was thinking about like, how does Mark, if it's his, wouldn't he have to testify? All right, let's see. Let's see. It would make more sense if it was Aidan's, right?
Yeah.
All right, wait, let me see. I'm pulling it up. Well, I imagine there's something that you could be saying while I'm pulling this up, though. Yes.
Okay.
Yes. What a laugh.
I mean, I
Wow.
thought it was like right there. It'd take you 2 seconds.
Yeah, but I've got like a million tabs open and you didn't tell me you were going to want me to pull it up. So it's like, and I like the first thing I pulled up was Bederow's first affidavit.
And it was Bederow's?
I don't know. I didn't go to the bottom to look.
At the top, it will say, I so and so.
Yeah, but like for whatever reason, I'm way deep in. Oh wait, I found it. Never mind. Got it. Yeah, I'm like 30 pages into it. All right, so let's see. Yeah, Mark Bederow. I am the attorney of record for Aidan Kearney. I'm familiar with the facts and circumstances. And he makes this affidavit in support of Mr. Kearney's motion. So there you go.
I mean, he reviewed the facts, and this is what the evidence shows, and he's citing to the evidence. So
He's citing to the evidence.
right. All right. Okay.
Yeah.
Okay.
Okay, Walmart. Yeah, it's signed off by Mark.
So and throughout the affidavit, he destroys Peter's credibility. It completely falls apart. In March of 2020, quote, Miss Peter engaged in a harebrained scheme where she forged documents and fraudulently filed them to advance her position and harm Mr. Kearney in connection with a petty YouTube copyright dispute. What did she do? Quote, Miss Peter brazenly sent YouTube what she falsely represented was a federal copyright civil complaint dated March 24th, 2020, that she filed in the District of Massachusetts. But, quote, in fact, the ostensible complaint Miss Peters filed was a forgery, and there was no federal lawsuit involving Mr. Kearney and Miss Peter. And we know the receipts for that. He talked about that on the show. She like left like some other complaint in some other case that she copied and stuck up there like the case number or some sort of filing.
Yeah, it was evident that it was fake.
Right.
Like, it was fucking insane.
She literally forged a federal court document.
Where do you have to be in your life to like sit around and hatch some fucked up shit like that? You know what I mean? It's like there is no point in my life where I could ever see myself being so obsessed with anything that I'm sitting there cooking up these kinds of schemes.
Oh, but wait, it gets worse.
No.
In May of 2023, Peter orchestrated an even more diabolical scheme. Quote from the affidavit, quote, on May 28th of 2023 at 3:30 p.m., concealing her identity under the alias Mia Rose, Miss Peter shamelessly emailed Mr. Kearney that Colin Albert was a drug dealer and that he was responsible for killing Mr. O'Keefe.
Mm.
She sent him like fabricated screenshots and lies, according to the affidavit, fabricated screenshots and lies about the Albert family, hoping that Aidan would report it so that the Alberts could then claim witness intimidation. Like, she's literally setting him up.
It's fucking crazy.
This is their key witness who they're like working with to bring him down.
It's crazy. I just don't understand it. I cannot, and there were some obsessed people during the Karen retrial, and I know that you weren't on social media like I was.
Right.
And I didn't like trudge into the muck with these fucking people. I mean, there was like the Julie Carpenter kind of crew that kept trying to like shame me because I wasn't declaring people awful people or whatever, and I'm like, dude, fuck off. Like that's your thing. That's not my fucking thing. And frankly, I don't agree with anything you say. You're like a victim petting like piece of shit. So, but dude, it's like the amount of people that have sat obsessed with this case to where it has really taken over every other aspect of their lives. It's like, you start hearing people like talk about touch grass. Like, dude, there were so many people in this case involved, like this weird war of like people obsessed with the fact that they believed that Karen Reed was guilty, took it upon themselves. And then obviously at the behest of the Commonwealth, started this like the kind of reverse smear campaign. It was such a weird thing. It was like it was the same shit that the murder sheet was doing with me during that case, during the Delphi case.
It's like there's a
It
handbook
continues in
somewhere
their
for this
fucking
shit.
piece of shit book. Like they still are coming after me in their book. Oh, I am a shill for the defense. I'm like, oh, fuck yourself, dude. I wish.
Did
I
you
happily
get a couch though?
I did not get a couch. I deserved a couch. I didn't get one though.
All right. So does the affidavit give a smoking gun for Peters?
I think so. So Peter, the smoking gun is this. Peter admitted all of it on a live stream, saying that on May
Quote,
29th, 2023, during her own live stream, Ms. Peter gloated about her disgraceful conduct, which she oddly thought harmed Mr. Kearney and made her look good. Amused by her little fib, she proudly admitted that the defamatory and false information she provided Mr. Kearney about the Alberts was 100% a fabrication made out of my mind.
oh my Lord.
And then she said, I sent this just to fuck with Aidan. I mean, dude.
Oh boy. The affidavit outlines threats she made, her threatening Aidan, quote, I know that bad things are happening to you right now, Aidan, and you're probably thinking that it might be me, but it's me. Just so you know, every single annoyance, every single horrible thing happening to you right now. Yeah, I've done it. Call the police, you bitch. End quote.
Wow.
This is the person the Massachusetts State Police decided to work with as the primary source. Come the fuck on.
Wow. I mean, credible. Not much. So, all right. We then kind of shift in terms of the affidavit, shifts into really what I believe the thrust of this entire campaign against Aidan was, and getting him arrested and charged under these witness intimidation statutes, which was to fucking shut him up, to silence Turtleboy. And again,
the campaign.
Yeah, I mean, it was the campaign to silence the turtle. So, as always, the timeline here is crucial. And on April 10th of 2023, Miss
Quote,
McCabe.
you're not saying quote.
Oh yeah, these are all everything that I'm saying. That's here. I got to remember to pull my slide up. This
Oh,
was the
that was
last
I
quote.
read that
All right,
one.
see, I'm falling behind on the quotes.
Yeah, you focus on the quotes.
Okay. You mean the
I mean,
slide?
the slides, yeah.
The slides. Okay. All right. I'll focus on the slides. You can talk about the quotes then. I'll make sure that the paired slide is up when you're discussing the quote.
Oh, I'm doing all the talking?
No, no. But you can do
Alright,
this
well,
one.
give the timeline because 'cause we're
Right.
not to that quote yet. It'll be there.
Okay. So on April 18th. So since
No,
what?
no, you were still on
Oh, I got
the
the wrong one. Wait, I gotta go back. See, it gets very confusing for me
no,
when I'm
you don't have one for this one, so just leave it there
oh, oh, okay.
until the next
On
one's
April 10th of 2023, Miss McCabe and the Alberts learned that they were subjects of a federal investigation into the Commonwealth's investigation of Mr. O'Keefe's death and its subsequent prosecution of Miss Reed. And that is a direct quote from page 16 of the affidavit. And then what
yeah.
happens next? For this, I do have a slide. Boop.
Quote, "On April 18th, 2023, Miss McCabe's and Albert's concerns were amplified when Mr. Kearney, citing the publicly filed defense motion and exhibits as his primary source, blew the lid off the Reed case by publishing his first Canton cover-up article."
Yeah. Yeah.
And then Jennifer McCabe immediately demanded action.
She did? What'd she
Yeah.
do?
Quote, "On April 20th, 2023, no doubt concerned about the viral dissemination of Mr. Kearney's article and its detailed exposure of the Reed defense motion, Miss McCabe contacted authorities demanding they do something."
Do something about this
Yeah.
man.
Yeah.
Who are these men who always wanted to be a nurse? Oh, yeah.
All right. So, quote, "On May 30th, 2023, Miss McCabe unsuccessfully sought a harassment prevention order against Mr. Kearney. What was her justification in this, for doing this? Quote, "Demonstrating her fundamental misunderstanding of the First Amendment, Miss McCabe alleged that on April 18th, 2023, and that's the day he first reported on Reed's defense motion accusing Miss Cabe of complicity in Mr. O'Keefe's death, Mr. Kearney attacked her character," end quote. She literally wanted to, quote, "do something so he can't blog about me. Do something so
Do
that he cannot
something.
blog about me.
Anything to
I
stop,
don't want
man.
him blogging about me." Basically, that I take all that shit like, y'all better do something if you want my testimony at the, period.
Yeah. Well, you know how much weight I give her testimony. So,
But the
but
DA
that's
gets
not all.
involved,
There's even
right?
more. There's
Yeah.
even more. This is where it gets really bad. On July 16th
Quote,
of 2023, quote, on July 16th of 2023, no doubt reeling from the perfect storm created by the ongoing federal investigation, Miss Reed's aggressive defense, and the public's increasing awareness of the growing scandal resulting from Mr. Kearney's reporting about the Reed case, DA Morrissey, from his personal email address, essentially begged the Massachusetts Attorney General's office, the AG, to prosecute Mr. Kearney for witness intimidation and or civil rights violations, end quote, page 23 of said affidavit.
wow, so the elected district attorney is using his personal email to beg other agencies to prosecute a journalist.
That is fucked up, man.
Yeah.
Okay, so in my estimation, this next quote is probably one of the most damning paragraphs in the entire document. And it starts, quote, "By issuing a statement on behalf of witnesses with interests that differed from his own, DA Morrissey allowed himself, the elected district attorney, to be exploited as a puppet whose strings were controlled by influential private citizens motivated to advance their self-serving agenda, which included silencing Turtleboy," end quote, pages 25 and 26 from said affidavit. I mean, that's damning shit, dude.
Yeah. I mean, and then they, the affidavit sets out how Peter becomes the prosecution's, like star helper. And it's where things get kind of insane. Despite knowing about Peter's history of forgery and lying, the prosecution welcomed her with open arms.
Come on in. The water is fine.
Quote from the affidavit, quote, "For months prior to the grand jury proceedings, D.L. Tully and Mr. Mello," is it Mello?
Yeah.
Okay.
Mellow yellow.
I don't want his name to be Mello because it's Mello. Welcomed unvetted evidence and guidance from Katherine Peter, a private citizen who they knew harbored an unhealthy obsession and hatred for Mr. Kearney. And that's from page 8.
I mean, in their eyes, because look, we could pretend that this was all just Kate Peters wanting to fucking get back at Aidan, but everyone from the Commonwealth side, including the attorneys and the witnesses on that side, all wanted to shut him the fuck up. Like,
Yep.
and she was the perfect person to do so. And they obviously did not care about all of the warts that
Nope.
come along with her.
Warts and all, we'll take it. Come
Yeah.
on in. The water is fine.
Water is fine. All right. So I think I'm way behind on some of my little guys here.
All right, you just stick with the little guys and I'll do all the talking.
Oh my God. All right. Oh yeah.
Unless you've got a dual screen. This shouldn't be so difficult for you.
I know you've made me very fucking self-conscious about looking at the like Allison's like, you look like a fucking idiot when you look at the second screen. I'm like, what? Like I've been doing that for like 2
but you don't
years,
need to
and now
look
you're
at the
telling me-
second screen because you have it right in front of you on the main
No,
screen.
I've got the slides on the second
That's
screen.
what?
But
But
you're mommy.
okay.
That's where
This
they're
makes
at.
no sense.
All
I'm
right.
so confused.
Oh, don't
All
be
right.
It's
So,
well, you refuse to use this. You're like the only YouTuber on the planet that doesn't use two screens. So, you know, that's what like we get those giant gaps of silence. It's because you're on one screen trying to find all the shit that you have because you refuse to use one of those giant, enormous Thunderbolt
it's
displays.
all the way over there. Like I would have to be like this. It's like so far away.
They're huge, though. They're huge. All right. All right. Let me
all right. So are you caught up to us? Yes.
I think so. Yeah.
All
okay.
right.
Yeah. I think this is
all right. So then it goes, wait, where was I? Okay. So then they go on to say, quote, "Miss Peter provided D.L. Tully and Mr. Mello with video and audio evidence, including edits from Mr. Kearney's lengthy episodes, which she believed evinced Mr. Kearney's intent to intimidate witnesses." But here's the key. Quote, "As detailed in the accompanying affidavit of Courtney Healy, according to Dr. Tully," to D.L. Tully, that's
he's no doctor, my friend.
Detective Lieutenant Tully, Miss Peters directed him to specific timestamps of Mr. Kearney's episodes, which he located and edited, rather than review the linked files provided to him by Miss Peters. All right, so by Miss Peter. So Peter is literally directing law enforcement on what evidence to look at and how to edit it. That's basically.
Sounds like it. It sounds like that's exactly what she was doing.
All right, so the petition, the affidavit goes on to say, quote, "D.L. Tully apparently renamed the edits." Now, this is going to that intent folder, and that they said in the motion how they presented to the grand jury that there was this intent folder that Aidan created. So now here's the quote. "D.L. Tully apparently renamed the edits he made from Kearney's episodes such that they didn't accurately reflect the names created by Mr. Kearney and saved them in folders he created, which included at least one he named intent.
Yeah. I mean, we're in there. We're one of them. I think I don't know if I was on Aidan's show or he was over here. I don't know where it is, but we made the list, or I made the list. I think it's Defense Diaries. I can't remember.
Bob Mata.
But we're there. Yeah, it's like, man, come on, dude.
So
Keep me out. Keep
so
me out.
Detective Tully, see that's where they're going to have a problem. If Tully created the folder and called it intent, now it'd be one thing if Peter created it, right? And then Tully got confused. Oh, I thought she said that was Aidan's folder. I didn't realize but according to this affidavit, Tully created the folder called intent, filled it with the edited, renamed versions of Kearney's content, and then told the grand jury that he labeled it intent? Or did he just pull it up in front of them? This is his thing, and it had the name intent, so it made it seem that way.
I think it's the latter.
Either
because
way.
for the purposes of meeting the statute, I mean, intent was one of the things that they had to show.
He outlined his intent there for us in this intent folder.
Fucking folder called intent. How's that for intent? You like that? That's fucking intent. I mean, it's insane, dude. It's insane.
So now,
like the whole concept of it, we joke a little bit, but it's repugnant. Like the concept of any prosecutor and or cop going in front of a grand jury, which, as we all know, what can you indict?
a ham sandwich.
A ham sandwich. It's already easy to indict people, but to have them go in with this kind of chicanery, with this kind of ballyhoo, with this kind of shenanigans is fucking disgusting and more importantly, terrifying. It's terrifying.
Yeah. Yeah.
It's absolutely terrifying.
Then it goes on to talk about Peter's surveillance. And this is a quote, and this is important because here it says, quote, on information and belief. And that's what you have to say, just legal jargon, when it's not something that you have seen the evidence of with your eyes, that you have personal knowledge that this fact exists. So all of these other paragraphs where he's not saying on information and belief means he's read the email, he's read the grand jury transcript, he's read, so this next paragraph is on information and belief, which could still be someone told it to you and you very well believe and know it to be true, but you don't have personal knowledge of it. You didn't hear it happen. So on information and belief, KP referred to Miss Peter, and she helped the MSP coordinate Mr. Kearney's arrest by monitoring him beforehand. And that's according to MSP radio transmissions.
Dude, that is fucked up. It's like that is so fucked up. I can't even with it. I can't even. Like, that's what I'm saying. If I'm a judge sitting on this fucking thing, some people are gonna have to come in and explain themselves. Like that's all there is to it. Like I need to hear from Tully. I want to hear from Morrissey. I want to hear from Kate Peter. And if I'm the judge, I'm hauling their ass into court and making them do exactly that, without question.
I mean, he says that after Kearney's arrest, quote, Miss Peter, with the blessing of Mr. Mello and Detective Tully, became an integral part of the prosecutorial team.
An integral part of the prosecution team.
Good, you've got the rest of that quote up there.
I've got it. Working on the case?
No, on October.
Oh, on October 25th of 2023, Miss Peter emailed DL Tully that she and her team were working on the case, and that's end quote, page 46. her team of miscreants and like angry, bizarre people just out there that like I've never seen a case like the Karen Reed case. And like as fucked up as Richard Allen's case was online in terms of the social media thing, the magnitude, the size of, because everything was able to be viewed by everybody who chose to want to watch it in terms of all the hearings and obviously the first trial and then the second trial, it created a much larger audience in terms of who was paying attention to this case. And then once people got sucked into it, I mean, how many people did we meet through like our kids' sporting events who are like, oh, I watch your YouTube channel and I'm fucking obsessed with Karen Reed. And this is like somebody living in the outskirts of Chicago
middle of nowhere
that are like obsessed with the Karen Reed case. It was like, I haven't seen anything like it since probably OJ was like,
right.
where
And of course she had a free Karen Reed thing on her yard.
oh,
So I mean, there wasn't anybody that I found that was like, oh, that woman's guilty.
yeah, no,
I mean, obviously they exist. We've seen them all out there, but
yeah,
you know. But so the affidavit also outlines that in March of 2024, Peter boasted, quote, Mr. Kearney is angry and upset with me because I have been cooperating with the prosecution and giving them information on him. He can't blame me for all his problems because
you can blame me.
oh, he can blame me for all of his problems because I am furnishing information. And that's from page 50.
Ooh, I mean, that's pretty damning.
Yeah.
It's pretty damning. So what else we got?
Well, he outlines, the whole grand jury deception. And it's at the heart of the alleged conspiracy. The affidavit alleges that, quote, the primary evidence used to secure Mr. Kearney's indictments was shortened, edited, and renamed segments from his hours-long YouTube episodes, which had the effect of skewing the true context of Mr. Kearney's episodes. Quote, at least 28 times during the course of the grand jury proceedings, Mr. Mello elicited from D.L. Tully materially false and misleading testimony about Mr. Kearney's YouTube episodes, which gave the grand jury the false impression that he created the episodes to document his alleged intimidation of witnesses.
28 times.
Yeah.
It's going to be tough for the Commonwealth to argue that that was an accident. Right.
Yeah.
Whoopsies. Oh. I mean, you do it 28 times. That's a pattern, my friend.
Right. The affidavit includes a devastating chart. Now, is that something you have?
I don't know if I have it. Let me see if I've got it. The chart.
No, because I'll just discuss it. Showing how the prosecution lied about Kearney's episodes. Let me just give you a few examples. The episode testified to as, quote, trying to destroy Colin's life was actually titled Karen Reed Case. Commonwealth tells more lies about John O'Keefe's GPS data. There was an episode an episode called Life as Normal is Over, which was actually, quote, breaking Karen Reed's defense files. Breaking Karen Reed's defense files motion to recuse Judge Cannoni and oppose gag order. What the prosecution called, quote, enjoying watching witnesses squirm was actually, quote, pre-vacation show Fupaceras, Jill Daniels, Carl Dougal, Taillight Mystery, Liz Proctor. But so then this whole intent folder deception 14 times. This is a quote, 14 times during the grand jury proceedings, DL Tully improperly testified that the grand jury exhibits were maintained in a folder titled Intent. Oh, I thought you were going to bring up the chart. Is that what you were going to do?
So the way that it works in the affidavit is it's all hyperlinks. So like every exhibit's in there for the hyperlinks,
AKA the receipts.
the receipts.
The reason why he doesn't have to say on information and belief. Like
Correct.
the actual personal knowledge of this shit.
Right. So, I mean, do you want me to bring it up?
No, it's fine. I
'Cause,
gave
like, the
everybody.
problem for me is in terms of
No, I mean, I gave everybody the
yeah, because I mean, there's a fuck ton of receipts.
But-
There's a lot of exhibits attached. A lot. I mean, we'd have to do a whole nother live to go through each of the exhibits because
No, we're good. We're good. So also the affidavit says, quote, Mr. Mello and DL Tully concealed from the grand jury that DL Tully, not Mr. Kearney, created and named the intent folder, and that DL Tully, not Mr. Kearney, renamed the clips DL Tully edited from Mr. Kearney's actual episodes. So, I mean, they made it sound like Kearney created the folder called Intent to store his intimidation videos. End of the day, that's, you know.
yeah. Gray Space says it took Melanie 3 lives to go through it all.
Oh,
Yeah.
Lord.
No, thanks.
So if you want a more detailed breakdown, we would suggest you go to our good friend, attorney Melanie Little, who apparently has a 3-episode.
And those must have been like 5 hours a piece, right? Like they had to have been a lot.
But Melanie Little has been following this case from the beginning diligently. I think she has the most expansive coverage there is. So if you want and need more, if you're yearning for more after that, go check it out.
15 hours total it took her.
Wow. She's dedicated.
Woo! That's a lot. That is a lot. That is a lot. All right. So I think am I on the right slide? I think maybe.
Yeah, we just did that one.
Okay.
I don't know what your next one is, but the next quote I'm going to discuss is, quote, Mr. Mello and DL Tully further deceived the grand jury by playing edits of Mr. Kearney's lengthy episodes and then depriving the grand jury from the complete and accurate context contained in his actual episodes.
Context is everything.
Well, yeah, remember Kearney's episodes were typically 2 to 3 hours long, covering multiple topics with, and this is how they refer to it, quote, elements of comedy and satire. And the prosecution showed second long clips without any context, and they flesh that out in the affidavit. They really do.
Yeah. And you know, I mean, context is everything. Just look at our Dateline episode. Like there's a good example of context is everything.
Yeah. The prosecution also used an entire day of grand jury time on an allegation that they never even charged. Quote, all of the evidence Mr. Mello presented on November 28th, 2023, related to the uncharged allegation of Mr. Kearney illegally recording a phone call with Mr. Scanlon. And that's from page 54 of the.
Yeah, and I mean that was obviously done to purely poison the grand jury against Kearney, right? I mean, even though they decided not to charge him with wiretapping, it was like it still had the effect.
Right, and that was what we went over in the memorandum of law, where Bederow explains why, you know, that's misconduct.
Totally. Like framing something in one way in order to cast somebody in a certain light, it's fucking bullshit, man. It's scary is what it is. It's like beyond everything else. This is scary because this can happen to anybody. And if we don't call them on their bullshit, if we don't stop the government from doing things like this, then we're living in a very, very scary world.
Right. And then the affidavit goes through all of the evidence suppression scandal where that they've made these specific demands for evidence starting in 2024. September. And they say, quote, despite numerous defense demands for specific evidence from September 2024 to August of 2025, the DA has failed to disclose exculpatory or discoverable evidence, or at a minimum, explained what efforts, if any, it has made to locate the requested evidence.
I mean, that's what it boils down. Like sometimes in terms of us getting discovery from the state or the Commonwealth, as it were, it can be a struggle. I mean, there is a lot of back and forth sometimes with getting discovery, and sometimes we'll have to go in and litigate it. But in this circumstance, when you have the allegations that exist here, and then when you compound it with the fact that they were refusing to turn shit over, it reeks of impropriety. Like
Right.
they're not going to go in and be able to make any kind of argument where any judge is going to be like, okay, yeah, whatever, the hard drive was fried or whatever, we lost everything on this flash, or we tried to turn it over and the CD was blank, whatever the fuck. Like prosecutors always come up with all this bullshit.
Yeah, we saw it in the care.
You saw
Yeah.
it. Like, you saw
We
it in
all
the
saw it.
underlying case that existed. But when
Right.
you have this backdrop of everything that's been alleged in this affidavit, and then you look at their refusal to turn over this evidence, you can't help but think anything other than
What the
this
hell is going on?
is this is some bullshit. Like
Something
this is
stinks.
something stinks in
So
Norfolk.
right. So the affidavit goes through the whole late disclosure about critical evidence about Peter's involvement wasn't disclosed until 2025. And he says, quote, communications between Miss Peter, Mr. Mello, and DL Tully, which are relevant to the instant motion to dismiss the indictments, have been in the Commonwealth's possession, custody, and control since 2023 and were the subject of specific demands on September 12th, 2024, October 8th, 2024, and October 17th, 2024, but were not disclosed to defense until months after the court decided our initial motion to dismiss. That goes directly to why they should be allowed to rebring this motion.
Here, here.
Here, here.
I mean,
Then they talk about disappearing evidence, which gets really suspicious. Quote, the DA now claims that numerous, quote, private links containing discoverable information about Mr. Kearney that Miss Peter provided to Mr. Mello and DL Tully has since been deleted by a private party, i.e., Miss Peter. Well,
oopsies.
if she sent because they're links. Okay.
Oh, pretty convenient.
I don't know that those can be recovered or not on I mean, that's like if you share a file, like you give someone a link and you share a file and then you delete that file or change stuff in that file, then they don't have what was there before. So
Yeah,
I
I
don't
mean,
know.
it's not gonna be the same concept as
Right.
extracting a phone. That's for
No.
fucking sure.
Right. So this goes to what we were saying in the motion to dismiss, that they do have evidence that specific stuff was deleted that they're never going to have access to. And, that the Commonwealth has said was, what is it, relevant to the
Yeah, I mean, look, the bottom line is in this particular type of circumstance where they're disappearing evidence, I mean, it points a certain direction. It's the convenience of this smoking gun evidence that has now vanished off the face of the earth is gonna weigh against the Commonwealth. It has to.
Yeah, but and he goes on to paint that these are false claims about the links. So he says that the Commonwealth claimed, quote, DL Tully has never opened any unsolicited links emailed to him by Miss Peter, but they have not and cannot say the same about Mr. Mello, who not only opened private links sent to him by Miss Peter, but sent them to DL Tully for him to review. They go on to talk about the Brady violation. Quote, Mr. Kearney has been prejudiced by the non-disclosure and or destruction of exculpatory and discoverable evidence because the defense has been deprived of critical, substantive, and impeachment evidence in support of the claim that the DA's biased and shoddy investigation relied upon unvetted and possibly tampered evidence from a source with a patently obvious motive to falsely accuse Mr. Kearney and with a track record of doctoring evidence against him on at least 2 occasions.
Oof. Oof.
Yeah. So the affidavit goes on to flesh out how prosecutor Mello's conflicts and just to flesh out prosecutor Mello's conflicts and his misconduct. Um they basically set out how Kenneth Mello had has made himself a material witness in the case, which legally disqualifies him from prosecuting it, which is a non-issue at this point. But what they alleged was, quote, Mr. Mello's communications with D.L. Tully and Miss Peters regarding her relationship with and the production of evidence to the prosecution, the likelihood that he will contradict D.L. Tully's claims that he never reviewed private links sent by Miss Peter, his knowledge of Miss Peters' motive to falsely accuse Mr. Kearney, and her overall lack of credibility, his knowledge that D.L. Tully edited and renamed evidence that he later introduced to the grand jury, and his conduct before the grand jury, which included eliciting false and misleading testimony from D.L. Tully, supports Mr. Kearney's defense and will make Mr. Mello an essential defense witness at trial.
100%, which is why he was bounced from the case. Like, he's an essential witness for the defense.
Yeah.
I mean, it's like there's no two ways around. I mean, shame on these people. Like, seriously, fucking shame on these people. What a just a violation of citizens' rights. Like, these people that have this power that run around and do this shit at the expense of citizens are the worst of the worst. They're the fucking worst of the worst.
But,
This whole thing is shocking to me in terms of just like trying to drive home a conviction on a guy that they're trying to shut up. Because that's when you just are trying to narrow it down to one common theme. That's it. Like, they just wanted to shut this dude up.
well, speaking of shocking examples of prosecutorial misconduct, read the quotes you have in this slide.
So, Mr. Mello also made himself a material witness when, on November 5th of 2023, in his official capacity as Mr. Kearney's prosecutor, he called the police advocating on behalf of witness Chris Albert by seeking to have peaceful protesters assembled across the street from Mr. Albert's pizza shop charged with witness intimidation.
And in that call, they allege, quote, Mr. Mello initially identified himself as a, quote, prosecutor with the Norfolk DA's office. He immediately asked to speak with the supervising sergeant. Mr. Mello reported a, quote, protest occurring near Mr. Albert's pizza shop and requested that a police car respond, quote, to make sure they are not intimidating. And then when told the protest was peaceful, quote, Mr. Mello urged the Canton police to either charge or disperse them because they met every single requirement of that statute. According to Mr. Mello, these protesters were certainly there to influence Mr. Albert or whatever else the statute says. They aren't there for any other reason.
End quote.
That's what Mello said. He's like, certainly, that was an internal quote. Certainly, they are there to influence Mr. Albert or whatever else the statute states. They aren't there for any other reason.
Yeah, I mean, so if you bottom line it, Mello was literally advocating for the witnesses that he was supposed to be representing the people against. Like, what?
Yeah.
What? Like, this is like what goes on over there is, I mean, look, Chicago is corrupt as fuck.
Yeah.
we've had a bunch of governors go to prison. You know, Chicago is infamous for the political corruption, the cops that just do awful shit. But like this is like the next level. And they operate with this just this kind of impunity that they think that they're never going to get nailed on this shit. And you know, in the modern day, modern era, like there is when shit's on the internet, when shit's out there, it just never goes away. There are always going to be paper trails. I mean, it's really our only saving grace in terms of fighting against the government is that almost all shit that is ever put on the internet remains, you know, and this thing was just next level nightmare scenario where it ends up with Aidan being arrested and living with this thing hanging over his head. You
Yeah.
know? I mean, it's like
I
there's
mean,
so many angles to that side of it where, you know, everybody was like, "Oh, why isn't Karen coming on his show?" You know, like all that side of it is kind of an interesting aside. But at the end of the day, you know, the thing that matters most or what should matter most to Aidan is that this shit goes away.
yeah.
Like this is life altering in the worst way possible type shit that's going on here. And it was done at the behest, at least allegedly, of witnesses in the case. And then, you know, by a prosecution team that just absolutely wanted to shut down this narrative that was effectively changing people's minds. And I'm talking about the citizens out there,
Right.
like that were learning about this case
Right.
because
They
like
like it when it's only their words that get heard.
they love having their narrative be the only one out there. That's what
Wait
they're
a
used
minute.
to.
Wait a minute. We can't have this.
Who's this fucking
What are
guy?
these people saying?
Who's this fucking big mouth guy talking all this shit all the time? I mean, it's like, dude, it's and you know, I've had this discussion with multiple people about, you know, kind of what they think. And you and I have had the discussion about what we think about the concept as defense attorneys of kind of laying our cards on the table
We've said it in enough
pre-trial.
lives.
Huh?
We've said our opinion on this topic in numerous lives.
Are you trying to shut me down right
You can
now?
see I'm getting tired. I
I
want to
mean,
through
I
the
could,
rest of it.
yeah, you keep fucking yawning. What the
Sorry. I was trying to
wow.
hide it. I was trying to hide it.
Doing a shit job, just so you know.
Well,
It's about as
overall,
transparent as Tully and fucking Mello's like scam job here.
right. Overall, the affidavit, you know, sets and paints the First Amendment implications, you know, that this case is fundamentally about journalism, the First Amendment, that Aidan was doing exactly what journalists are supposed to do. Quote, Mr. Kearney, Mr. Kearney's investigative reporting has exposed numerous examples of fraud, corruption, and wrongdoing. It sets out how the results of his reporting speak for themselves. Quote, but for Mr. Kearney's reporting, and we spoke to this earlier, but disgraced former Trooper Proctor would still be investigating serious cases for the MSP. Other members of the MSP, including Detective Lieutenant Brian Tully and the lead investigator against Mr. Kearney and Sergeant, meaning Sergeant and Sergeant Buchanan, wouldn't have been publicly disciplined for their misconduct, and the Norfolk DA's state police detective unit wouldn't have been dismantled due to their misconduct in the Reed's case.
Well, the government's not very happy about any of that happening, but we,
No.
the people, are very happy about it. Or you should be.
Yep.
So like this is kind of getting down to where, you know, what we're seeing here in this case and what Mark has said on multiple times that he's been on our show, in which is the absolute truth that what we see here is the weaponization of the criminal justice system to silence journalism. And the affidavit goes on to allege that, quote, since Mr. Kearney exposed the scandals surrounding the Reed case on April 18th of 2023, the DA, the MSP, Ms. McCabe, and the Alberts have repeatedly used the criminal justice system as an instrument to silence Turtleboy and end the persistent criticism his reporting has caused and still causes them today. End quote. Page 7. And this was probably, I'm a big Orwell guy, 1984 guy. So this quote that Mark stuck in there, the Commonwealth unveiled an Orwellian plan in which they, the very people being criticized by Mr. Kearney, weaponized the witness intimidation statute for the purpose of silencing his criticism of them.
For sure. And if
I mean,
this is allowed to stand, it sets a terrifying precedent for any journalist who dares to criticize law enforcement or the judicial system.
For all of us as citizens, not just the journalists. I mean, we rely on journalists for shining light and disinfecting the shit that's going on behind closed doors in our government. And if we don't have that, like I say it all the time, we're not going to live in a country that we want to live in anymore because everything would change. Everything. Read some history. If you don't understand what happens when journalists are silenced by those who don't like being criticized by them, it's a very scary place. And history tells us that. Don't believe me. Look at history.
Yeah. And I mean, just to summarize, the defense is asking for 3 things. 1, the dismissal of the indictments due to grand jury integrity violations. 2, the dismissal for Brady Giglio violations. That's the failure to turn over favorable evidence or exculpatory evidence. And 3, the disqualification of the prosecutor, which is a non-issue because, and the reason it's a non-issue is because she, as Kathy Peter, now sued the prosecutor, right?
Yeah. I think
I don't know what's going on.
I don't know if she filed suit like somebody
I
in
thought
charge.
that's what it was. I don't know.
Like Gaetano did. I don't know if Peters did. I don't know. I don't know what the fuck she
But
did.
they're gone. They're out. They're out.
They're out. They're out. So look, here's the bottom line. If these allegations are true, this represents one of the most egregious examples of prosecutorial misconduct in recent memory. It's not just about Aidan Kearney. It's about whether journalists can investigate and criticize public officials without facing criminal retaliation. And I mean, we have to have it that way. We have to have it that way. Otherwise, it changes the fabric of our society.
And remember, this isn't just talk. This isn't pure speculation. The affidavit has 88 pages of specific allegations with extensive documentation. The defense has provided the email communication between Peter and the prosecutors, grand jury transcripts showing the false testimony, evidence of the document forgery and perjury, records of evidence suppression, proof of prosecutorial advocacy, and on and on and on.
And so ultimately, what the good judge is going to have to decide here is whether or not to grant an evidentiary hearing to examine these allegations, which if he doesn't, I will be stunned. I mean, out of his own pure interests, I would think that he would want to have an if I was on the fucking bench and this thing came across my bench and I'm reading it, I'd be like, I'm in. I want to hear it. Like, I want to see it. Like you've got this evidence here. I want to see it fleshed out. Because if this shit's true, we got some serious problems in the Commonwealth.
Yeah.
So if that, he's also got to make the decision on whether or not he's going to dismiss the indictments outright. Now, Mark and Tim Bradel have been successful in getting several of the indictments dismissed. We still have these several that are pending, which again are just constantly floating as a dark cloud over Aidan Kearney's head. And then finally, whether to disqualify the special prosecutor, which
is a non-issue now.
Non-issue. Moot.
Why don't you give me your final thoughts before we move on to all of our supers?
Okay. I mean, look, to me, what's at stake is that this case is going to determine whether investigative journalism can survive in Massachusetts, not just Massachusetts, but everywhere. You set a precedent like this, it is incredibly dangerous. It is a incredibly slippery slope. Or whether the state can criminalize criticism of law enforcement and judicial misconduct. I mean, at the heart of that case against him, that's what's at stake. I mean, there's no two ways about it. I mean, that's exactly what is going on here. And so the evidence presented in this affidavit to me suggests a level of corruption and misconduct that should shock the conscience of every American who believes in the First Amendment and the rule of law. And for a final thought, I'm going to pull it directly from what Mark said in his affidavit. For the reasons detailed in this affidavit, its exhibits and the accompanying memorandum of law, the court should dismiss the indictments against Mr. Kearney and disqualify Mr. Mello, or in the alternative, order an evidentiary hearing on the motions because the prosecution has prejudiced Mr. Kearney by A, intentionally impairing the integrity of the grand jury proceeding, and B, failing to disclose specifically requested exculpatory and discoverable evidence in their possession, custody, and control. And Mr. Mello's conduct has made him an essential defense witness.
All right.
So, I mean, look, it's absolute yeoman's work by Bederow, per usual. The
And
guy,
again, you want a more detailed blow by blow, play by play, read through, check
all
out
the exhibits. Apparently, Mel went through all the exhibits.
Attorney Melanie Little.
It seems redundant for us to do it. But kind of the last thing that I want to just restate, which I stated during the Karen Reed case, is that the one thing that I want you all to keep in mind as you watch these cases, and you have an interest in these cases, and if you think this is how normal courts operate, if you think this is how the criminal justice system operates normally, it's not. However, one thing that is absolutely gospel in this case is that Karen Reed had the ability and the money to be able to hire outstanding defense attorneys to represent her not once but twice in her cases. And as a result of that excellent counsel she had from her attorneys, she was acquitted. Because I will tell you, had they not fought as hard as they did, and you saw through 2 trials exactly what they had to do to overcome the Commonwealth's absolute fervor to convict her. And but for her having the resources and support to be able to get those types of attorneys to do the amount of work that they did on that case, she's going to prison. And it's the same fucking thing for Aidan Kearney. Aidan Kearney has Tim Bradle and Mark Bederow, who are putting together an incredible defense for this guy. Because if Aidan didn't have money and Aidan had just been assigned a public defender, none of this shit, you are not seeing 88-page affidavits accompanying a 35-page memorandum of law digging into all the shit that Bederow is digging into.
Right, because he's not just saying
happen.
things. He's got the corresponding exhibit attached to everything. That's why I pointed out when he used on information and belief.
Yeah, I mean, but the bigger point is that it takes this type of lawyering on the defense side to really
Even attempt.
have a fighting chance against our government. And I just want you to keep that in mind, because there are thousands and thousands and thousands and thousands of defendants in this country that are not afforded the same resources, and they go into these courts and they just get fucking hammered by the government. And I just want that to kind of to ruminate with you, because it's true. And you should think about it beyond just Karen's case and Aidan's case. Think about it on a grander scale. And it's what we talk about on this channel all the time. I have wrongfully convicted people that have been exonerated on this channel, and I get like 400 people watching instead of 1,500. So it's like, if you really care, like you purport to be caring about Aidan and the issues that are involved with this case, prove it. Do something about it. Watch it. Like, we put a lot of good content on this channel, and Allison and I are pretty ferocious in terms of our defense of the Constitution in this country. And I don't know if there's a channel out there that does it the way that we do. So for
All
that
right.
purpose alone, I'd like you all to subscribe, like, and share. And if you're on replay, leave a comment. It really helps.
All right, Nicole
Yeah.
Maxwell.
Yes, I will be not only will I be at Purdue with Yannetti, I'm the one who set it up. So yes, I am moderating that event. I know I saw a bunch of people asking about the event, and it is taking place in Indianapolis, and it's an amazing event. With David's going to be there, John Ramsey, and a couple of wrongfully convicted people who have been exonerated, and then the couple from that insane Netflix series called American Nightmare, with the man and the woman and the guy was saying some dude in scuba gear came in and
And they were
fucking
like, "That's so absurd. It's so ridiculous. What the hell?"
Well, the thing that's so amazing about that panel is that we're going to have a lawyer, a wrongfully convicted person, a nearly wrongfully convicted person, and then we're going to have John Ramsey, who half the world still thinks killed his daughter. So it's like 4 very different perspectives of what I consider to be all in the wrongful conviction umbrella. So, but what I was going to say is I am going to, I'm working to get that thing streamed, because as it stands right now, and I'm on the board with our particular, with who's hosting it. And I'm trying to get it streamed. I will let you all know. And I know that there's been questions in there, and whether or not it was open to the public. I don't think that it is, but I will get a definitive answer on that, because I don't, like, I know that we'd sold tables, and I think that it might be sold out. So I don't know, but I'm hoping to get it all to you guys, because I think it'll be a really interesting panel and a really interesting conversation. So
Stand
all right,
by
babe,
for that.
go through
All right,
the
Nicola Maxwell, member for 2 months. Thank you for that. Free
appreciate
Dr.
that.
Turtleboy, enough of this kerfucklery.
Indeed.
Kelly K is a new member. What's she get,
Aw,
babe?
family hug. That's what
And
she
Kelly
gets.
K and not that soon.
Aw, family hug, not that Susan. Welcome, welcome, welcome.
All right, so Jennifer J25 has been a member for 23 months.
OG.
Oh, gee. Thanks for your continued support. Hope
Gee.
you're feeling better, Bob.
Thanks. I'm still a little under the weather, but I
Yeah.
powered through.
Yeah, he sounds a little better.
Yeah, Allie gave me some Mucinex, 2 big horse pills, and they really helped.
Yeah. Stacy, member for 12 months. Thank you for your continued support. Y'all smash that like button.
Thank you. Thank you.
Yes,
Thank you.
thank
Yes.
you, Stacy. Music to my soul. But who appoints the special prosecutor if Morrissey and his office are conflicted out? The state AG has already declined to charge Turtleboy with anything.
It's a $1 million question. Music to my soul. I don't know if you were late, but we were talking about that earlier.
Well, she's
Maybe
asking who actually appoints them or tries to appoint them. I think it's Morrissey and or the judge would still be trying to find that person. I don't know how the process works. That's outside of our purview.
Yeah, I mean, typically we'd have to ask a prosecutor, because I mean, when they're conflicted out in Illinois, we know that there's floating special prosecutors that handle cases all around the state, and they'll bounce in and out. So I don't
know if
know.
it's the judge or the conflicted out prosecutor's office that actually reaches out
Like
and
it shouldn't
selects
be them.
people. It does seem like it shouldn't be.
Seems like it should not be them at all. So yeah.
Thank you. Thank you.
Yes.
I was eating a mint, so I was hoping you'd
So
go.
Josh H says it, and thank you for your $5 gift there. If I was Aiden, I would fight this till the end, then file a 1983 suit against MSP. I mean, it's easy to sit there in your armchair and say it, Josh, and I understand.
And maybe he would. I mean, we don't know. I'm just thinking 100 and some years. Come on.
Yeah, it's like I've had clients where I've wanted them to fight for the principle of the thing. And it's easy as me being the attorney to try to encourage them to do that, to be the poster boy for whatever particular issue I felt required some kind of litigation because we had to shine a line on it. But it's a big ask of Aiden, because if they turn around and say, okay, dude, you gotta plead to something and we'll give you some disorderly charges, you know, and misdemeanor time served, done.
I would do it.
If I'm him, I'm taking that and I'm running with it. You know,
Yeah.
it's like
You've got to be able to move on with your life. You've got to.
yeah, because like the way that that statute is worded, I could see them being able to convince 12 people that the way that it's worded, that he violated it on its face. Because if they're able to successfully keep out the fact that this was satire in certain aspects and other aspects of the fact on how he conducts himself within his journalistic endeavors, I mean, you know, if you look at something on the black and the white, it's like that's why they charged him under that statute, because they believed that they could hammer it home. Because when you're just reading the language of it, there exists a possibility that it could fit. So that's a scary proposition for Aiden. You know, I wish I could say when I read that statute, it clearly didn't apply in any way, shape, or form.
It wasn't meant to, though.
But like, right, like this was not the legislative intent of that statute, to use it against a fucking journalist who, you know, again, whether you love him or you hate him, whether you hate his style, the way that he talks about people, the words that he uses, that's all one thing. The other thing is that he's a journalist and he's reporting on something, and he took a position, and it was his belief as a reporter that those people were guilty of these crimes. And that was his position. And he was merely reporting it, and they didn't like hearing it. And the prosecuting office didn't like hearing it. And the cops didn't like hearing it. And so they're doing this to silence him and now to punish him. So,
right.
You know,
Boris gifted 5 Defense Diary podcast memberships. Thank you very much.
Thank you, Boris. Appreciate that always.
Under your scars. Thank you both for the great lives.
Appreciate that.
Free Turtleboy.
Thank you.
Zach, member for 1 month. Thank you very much. Listen, Turtle. Bluebell. Thank you. I'm late to the party. Thank you guys for your hard work. You're the dynamic duo. Allie, you always make me laugh. Aw, thanks.
Me too. She's hilarious.
I very rarely make Bob laugh.
That's total bullshit. You're fucking hilarious. NR, member for 3 months. Thanks for the stream on my birthday. Happy birthday,
happy
NR.
Birthday.
We would do our song, but we just can't. We can't coordinate it.
We can't coordinate.
It's like we have to be in the same room. It's the only way it works. Otherwise, it's just off.
But happy
birthday. We're in the same room. It is on point.
On point.
On point. Jennifer 2L came back with a $2 super. Thank you so much. We appreciate you, Jennifer, always, and for being a super OG, by the way.
Yep.
Teddy Bear, I'm losing my mind. The prosecutors are still on this case. They're only off on the Lindsay case. Okay.
Oh yeah.
Groves off of Gaetani.
Damn it.
I still think.
I thought.
To me, it's all muddled. It's all part of the same shit, man. It's like, I think there's got to be a motion to get them booted off this one too. It's all interconnected. It's all intertwined.
They've probably been shouting that in the chat
probably
the whole time we've been saying it. Yeah, sorry.
Oopsies.
Oops.
Wishful thinking.
Thank you very much.
Thank you.
Teddy Bear.
Thank you. I'm curious, how many other cases have these types of things happened after getting warrants or indictments? We've already seen Proctor's impact on cases.
Countless.
Nancy, you don't even want to know. And forget about just Massachusetts. There's 49 other states that this shit goes on all the fucking time. Like I know that you people probably think that I'm just sitting here stomping my feet and standing on my fucking like crates, like shouting at you about all the shit that's going on in this country, but it is all the time. You just don't hear about it because it's not a high profile case. All this shit's under the radar. Y'all don't know unless you know. That's why I'm saying maybe check out some of our lives. Check out the thing that I did with Timmy, who's one of the members on that panel. Dude spent 24 fucking years in prison on some shit he absolutely did not do. And they railroaded him. And that happens all the time in this country. All the time. If you all think that it's just a Massachusetts thing, I got news for you. It ain't. It's all over. Open your eyes. And I know that these cases have opened a lot of people's eyes. So keep them open.
All right.
Ask questions.
KPT, member for 10 months. Thanks for your continued support. Happy to have found y'all. Well, we're happy you found us too.
Indeed. And then finally, Debbie King. Thank you all for doing what you do. We appreciate that. And thank you guys, all of you. Thank our mods. Thank you, Tracy and Mandy, for doing all that you do for us on a daily basis. We adore you. Mods, you're amazing. We couldn't have this amazing community without you. And you guys, without you guys, we've got nothing. So before I let you go and tell you how much exactly I need you, make sure you like, share, and subscribe. If you're on replay, leave a comment. It really does help get the live out to the world because nobody really knows how the YouTube algorithm works, but I think those things help. I think that they help. So, all right, y'all, we love you a million times over because without you guys, I would literally just be an old man
screaming into the void.
Into the void.